This is the matter of Daniel Richard versus Sherman Packard and Chuck Morris. I believe we have Mr. Richard on. Mr. Richard, can you hear me? I think you're muted.
There we go. Can you hear me now?
I can, yes. And I believe we also have Attorney Cianci and Attorney Lehman appearing on behalf of the Speaker and the Senate President.
Yes, Your Honor. Richard Lehman here for Senate President Chuck Morris.
Good afternoon, Your Honor. James Cianci on behalf of Sherman Packard, Speaker of the House.
Thank you. And I see that we have a number of other people on. I'm just going to ask that if you are not either Mr. Richard or one of the other counsel who just identified themselves, if you could make sure that you're muted so that we're able to conduct a hearing. And I'm sure I will have some questions for both sides. I have some questions for both sides here. But when I first hear from the defendants, then I'll hear from Mr. Richard. And I should let counsel know, and Mr. Richard, that I have reviewed both the motion, the memo of law, and Mr. Richard's memorandum in objection to the motion to dismiss. And I have reviewed the cases cited by everyone in support of their respective positions, as well as the constitutional provisions and statutes relied on. So I don't know if Attorney Lehman and Attorney Cianci, who wants to go first?
If it's okay, Your Honor, I think I'll go first and then stop halfway through, and Mr. Cianci will pick up if that's okay with you.
Absolutely, absolutely.
Okay, thank you very much. This really comes down to 2 questions, Judge, and that is, one, whether Part 1, Article 32 creates a mandatory obligation on the legislature to take certain actions in response to petitions or remonstrances filed under Part 1, Article 32. And 2, if it doesn't, whether the court is going to use judicial authority in an effort to compel the legislature to do something that's not constitutionally required. I know you've read the relevant provision from the Constitution, but I do think it's worth reviewing quickly. Part 1, Article 32 says, "The people have a right in an orderly and peaceable manner to assemble and consult upon the common good, give instructions to their representatives, and to request of the legislative body, by way of petition or remonstrance, redress of the wrongs done them and the grievances they suffer." I would submit, Your Honor, that there's nothing in there that creates a positive right in a citizen to force the legislature to take any action whatsoever. That provision provides substantive protections that are very important. It says the people may peaceably assemble. When they're doing that, the police or soldiers are not going to come and break up their meeting where they're talking about things that are of importance to them. That's an important substantive right, and they're right there in the amendment. They are allowed to give instructions to their representatives. They're allowed to say what's on their mind, what they want their elected representatives in the general court to do. Although it's not written into the Constitution expressly, it's always been understood that the people will not be retaliated against by the government based on the requests that they may make of their elected representatives. And they may describe, as they want to, the grievances they have and the steps that they want their elected representatives to take to redress those grievances. In New Hampshire, I don't think it's constitutionally required, but we've done it this way here for a very long time, unlike other states. Any member of the House of Representatives or any member of the Senate can introduce a bill about any topic, the only restriction being that senators are not allowed to introduce money bills. Every bill gets assigned to a committee by practice, and every bill that gets assigned to a committee has a hearing, a public hearing. In most other states, representatives who files a bill doesn't have a guarantee that his or her bill is going to get a public hearing. The chairman of the committee can do a a desk veto just by never calling assigning it to a committee. We don't do that here. When we do assign a bill to a committee, anybody can come off the street and testify, and it leads to some interesting testimony, but we think it's worth it. And finally, every bill that gets introduced, no bills get killed in committee. They all make their way to the floor, and they all get a final vote by the one body or the other. So we do more to permit citizens to address their grievances than just about any other state I can think of. Now, Mr. Richard he's obviously a bright man. He's done some obvious research. He's put a lot into his claim, and I congratulate him for that. But I would submit, Your Honor, that quite simply, the constitutional provision that he relies on doesn't compel the legislature to do anything with a remonstrance or petition that gets filed. There's simply no next step in the Constitution. He's protected from retaliation. He can file another one tomorrow. Well, probably not tomorrow, but Monday. There's nothing stopping him, and he makes no claim that anybody's tried to stop him from filing. The heart of his claim has to do with the action taken by the legislature in response to his filing. And the Constitution simply requires no specific response whatsoever.
Let me ask about one thing you said. What is the process from your perspective by which the legislature complies with its obligations under Part 1, Article 32, with regards to remonstrances? How does the legislature meet its obligations under the Constitution?
By not retaliating against somebody who files a remonstrance. I don't think that there's a requirement that the legislature engage in an act of formally accepting a piece of paper. A petition can be addressed to the legislature, it can be delivered to the legislature, it can be left at the House, but there's no obligation that it be filed away in any particular way. There's no obligation that it be recognized formally. It is simply Mr. Richards and every other citizen's right to address their concerns to the legislature. And I would submit that by addressing them to the legislature, that doesn't mean necessarily in the mail. It means speaking to them, whether through the press, whether through any other means of communication. They're by having a rally on the State House lawn, but not necessarily to have a document get filed away in a way that he appropriate, because that would be an affirmative requirement placed on the legislature, and there isn't one in here, and there is a corresponding constitutional provision to balance against this, and that is the provisions that state that each house shall make their own rules of proceeding. Those are very important constitutional provisions. The House and Senate each are fully authorized to make rules that are consistent with the Constitution. Nothing in any of the House rules is inconsistent with a constitutional requirement, unless you find, as Mr. Richard would like you to find, that there's an affirmative duty to do something with his petition or remonstrance. And again, I respectfully submit there is none.
So I do have one other question about the Part 1, Article 32. Mr. Richard makes a point that in the motion to dismiss, there seems to be a suggestion that there are no greater rights afforded under Part 1, Article 32 than are afforded under the First Amendment to the U.S. Constitution. Do you agree with that?
They're co-extensive, in my view.
Thank you. I'm sorry, I interrupted you. Please, I don't know if you had anything further.
I would rather answer your questions than hear myself talk anytime, Judge. The only other thing I would say is that absent a finding that Part 1, Article 32 contains an affirmative duty. Well, I want to talk about one other thing, the difference between positive and negative rights. Generally speaking, the Bill of Rights protects citizens from hostile actions by the government. It's the only instance in which I am aware that the Bill of Rights of the Constitution creates an affirmative right that requires the government to do something for somebody is in the court's construction in the Claremont cases of Part 2, Article 83. And that has been a controversial determination for going on 30 years now, because it's an affirmative obligation of the government to do a thing. The Bill of Rights is about protecting individuals from government action, not requiring government to take action to do a thing for a citizen that they want to have done. And Mr. Richard is asking you to, rather unprecedentedly, with the exception of the Claremont cases, find that government has an affirmative duty to him to do something with the paper that he wants to deliver to the legislature. And I would urge you not to do that, Your Honor.
Thank you, Attorney Lehman. Why don't I hear from Attorney Cianci before I hear from Mr. Richard?
Thank you, Your Honor. And perhaps to maybe try to answer your question regarding the scope of the rights contained in Article 32, as of course you noticed, there's relatively little case law in New Hampshire regarding this, which is why Mr. Lehman and I resorted by analogy to the First Amendment under the federal Constitution and Supreme Court cases decided thereunder. I also think the Gentry case from Tennessee, which we included with our filing, really is instructive because not only does it sort of concern similar facts, it involved a citizen of Tennessee presenting a remonstrance to the Tennessee legislature and then requesting the legislature to take some sort of positive action on that. The court decided that case under a similar constitutional provision of the Tennessee Constitution regarding petition and remonstrance. And also the plaintiff in that case sought a similar remedy as in this case, that being a writ of mandamus to sort of require the legislature to act. And so we would sort of urge a similar result as in that case, Your Honor, because what the Tennessee court found in relying both on the U.S. Supreme Court precedent, cases decided under other state constitutional provisions related to petition and remonstrance, that really the scope of the right, the limit of the right is in presenting the remonstrance, presenting, as Mr. Lehman said, that piece of paper or that email or broadcasting that message or protesting outside the State House to the legislature's attention. However, it doesn't require anything more than that. To the extent that the legislature chooses to take further action, as Mr. Lehman pointed out, that would be within the purview of the legislature under its own rules of proceeding to provide. And we would note under present circumstances, there are no House or Senate rules that deal with the issue of remonstrance. And so in the absence of that, the remedy of mandamus, that is requiring either the Speaker or the Senate President to take some sort of positive action, whether under existing rules or, as the plaintiff suggests, to require this court to mandate that the House or Senate adopt rules to deal with this. We just don't think that's required under the Constitution or any of the cases cited in our motions. Really, that, and I think the Tennessee court put it best that, the citizens certainly have a right to present their remonstrances and their petitions for redress to the legislature. However, that's where that's the limit of that right. It's then incumbent upon the legislature to decide what it wants to do with that information. It may, as Mr. Lehman pointed out, particularly in New Hampshire with 424 members, it may be in the form of taking the substance of somebody's remonstrance and turning it into a bill, or turning it into a proposal to amend the Constitution, or some other action. And that is the mechanism under our rules by which the legislature would take action on the subject matter. There is no requirement that it takes action on the remonstrance or the petition itself. And so that's where we would argue that this court's authority to mandate the legislature to act, whether via writ of mandamus or through injunctive relief, is limited. It's within the purview of the legislature to do that. And just finally, I would note, I did mention this, we did mention this in our motion, in terms of the plaintiff's remonstrance, even though not required, even though not contained within House rules, the House, in fact, did receive the remonstrance. It did, in fact, post notice of that remonstrance in the House calendar on 2 separate occasions, made it available to any person who requested it, and then in February actually took a vote. A single member brought a motion to the floor to refer the remonstrance itself to a committee. That was up for a full vote in the House. The House voted to table that, and it was not referred to committee. So even though not required, the House did decide to take action, which I think even more so shows that there are mechanisms where if the legislature wants to entertain the subject matter of the remonstrance, it can, but it has the right to choose how to deal with it. And so we would just argue that, sort of by way of analogy with the other provisions, other states, and under the federal constitution, it should inform this court's reasoning and result in this case. Thank you, Your Honor.
Thank you, Attorney Sansi. Mr. Richard.
Yes, sir. I'd like to address their comments. I took notes, and then I had a few things to say. First of all, Attorney Lehman references Article 32. And he's correct. Article 32 does not cause a cause of action on the legislature. Article 31 does. So he's in error that way. Number 2, he reinforces the right, and the right was not the current legislative process as he explains it. The right was the cause of action for the legislature to function for more than 100 years. And so that's a historical fact based on customs, usage, and precedent. The other part that he has said, the assembly clause. He takes the assembly clause out of context. The assembly clause, when you tie Article 31 and Article 32 together, it has a very specific meaning and not the meaning that Attorney Lehman referenced. Number 4, this is not about making law. The defendants here have not brought anything forward to address the repeal of bad law. What we're dealing with here is them discussing the petition process, and the redress by petition, as I expressed in my pleading, is very well explained, that it is not simply the request that the legislature pass a law, that the right of remonstrance is established by precedents here in New Hampshire. Our first remonstrance, established on February, I believe it's 1785, was very clear. There were no House rules. The provisions of the Constitution were causes of action unto themselves. They assembled as a body of the whole to consider the repeal of the Navigation and Commerce Act. And so it begins that way, and it's never changed. The next part is the legislature doesn't get to change how it legislates. Its ability to make its internal rules are very clear. Those rules, the authority under Article 22, Part 2, and Article 37, both prescribe that the legislature has the authority to establish the rules to carry into effect those powers delegated to them by the legislature, not for them to use those rules to avoid their obligations as previously established by usage and custom. The Tennessee case is different for a variety of reasons. One, relying on federal case law, as I expressed in my pleadings, isn't relevant here because the state constitution precedes the federal. It's stronger. Its provisions that I outlined in my brief are very detailed, and they're not the same. So you can't cite the federal constitution. You can't cite non-existent federal case law for a non-existent federal right. To continue.
I thought, Mr. Richard, and I read the Gentry case. I thought the Gentry case was talking about the Tennessee Constitution and specific rights afforded to its citizens under the Tennessee Constitution.
It does, but the problem that the Tennessee case has is it doesn't have the depth of the history and usage and custom of New Hampshire. And so Mr. Gentry has struggled with two issues. Number one, there's conflict between the website and the remedy provided by what he interpreted on the website as his, what he could require of the legislature. And so that's the nexus of their arguments, is that he's saying, hey, the legislature should act in a particular way as addressing whether they receive the remonstrance by address or however they're going to do it. So there's a lot of discrepancy within their case.
Can I ask you about your assertion that the Constitution obligates the Speaker to call and assemble the legislative body as a whole to provide a redress for grievances or remonstrance? Are you saying that anytime a citizen files a remonstrance, that the Speaker is obligated under the Constitution to call and assemble the body as a whole to address the remonstrance?
The obligation clause comes through the four articles. Article 31 and 32 create the obligation on the legislature. Articles 22 and 37, for them to make the effective rules, are there specifically for them to carry into effect their obligations under Article 31 and 32. And this is codified in great detail in the House and Senate journals for more than 150 years. When the defense claims there is no rules and they have no duty, they're omitting the fact that they're the ones that actually remove the rules, the previous rules that caused that obligation. So you can't say, Your Honor, we have no rule, we have no obligation because there's no rules. Well, they're the ones that removed the previous rules. You can't use the House Rules of Procedure to amend, suspend, or alter your duties and obligations, and that's what they've done.
I guess I'm asking a different question. I'm asking whether in your view, the Constitution obligates the Speaker to assemble the whole legislative body anytime a citizen files a remonstrance.
The Constitution itself doesn't, but the previous rules that were established to meet the needs and demands of Article 31 and 32 do.
Thank you. I'm sorry, I cut you off. Please continue.
And so I think that was basically, Attorney Cianci along the way established what I consider a confession. And that confession, and then both of them did, which is that the right does exist and that it is a substantive right. And the fact of the matter is there's no mechanism under the current rules, as he confessed to and conceded to, is to carry that into effect. So that's a big problem. And so let me see, the last two items I had on their notes were the House did not act in accordance with the Constitution or any rules because there isn't any. Representative Howard reached out to the Speaker, Paul Smith. He reached out to the Speaker, Sherman Packard, and asked them how can we move Mr. Richards' remonstrance forward? How can we get this referred to a committee? And they refused to answer. So in frustration, during a legislative session, he brought it up, but it wasn't provided the remedy that I base on usage and custom and previous rules. And so it was ignored. It's not supposed to be simply tabled, referred to a committee, because these obligations and these rights are for the legislature to decide. When they say they have no duty to act, they in fact are acting. They are acting to obstruct. One, by not seeing to it that there are sufficient rules in place for them to carry out their duties under Article 31, and secondarily, that they're not providing any rules now. So Rule 18, as it exists, putting this on file and giving notice that it's been filed with the clerk of the House might as well be thrown in the trash can, because that current rule is void of the previous cause of action. So, of course, they're telling the truth when they say there's no rules that bind us to move his remonstrance forward. They're correct on that. So I'd like to move to my prepared comments that I had for this hearing today.
Absolutely, Ms. Richard. Please go ahead.
Summary of the case here basically is this. The New Hampshire Supreme Court, in the case Representative John Byrd versus Speaker of the House, is similar to this case. The House used House Rules of Procedure to infringe on Representative Burt's Second Amendment case, on his rights. And so it answered the issues of separation of powers and justificability. That was a hard one for me to learn too. That word is a tongue twister, isn't it?
It really is for all of us.
So hopefully I didn't butcher the word, so please forgive me.
You did great. You did great.
All right. And so that case really deals with the fundamentals of this point, which is, yes, the legislature should and does establish its rules of proceedings, but it crosses a line. It crosses a line when it interferes with the fundamental rights of the citizens, because those rules and the authority to enact those rules are specific to carry out their duties, not to circumvent or obstruct their obligations. All the case law they cite, the defense cites, is irrelevant to this case in New Hampshire, because citing federal case law in First Amendment does not apply to this case. And all the defense citations are repugnant and contrary to the Constitution of New Hampshire and the historical precedents and usage and custom of this state. Number three, the defense has already confessed that it did in fact deny the plaintiff his rights to redress a public grievance. The Constitution and the established precedents, usage, and custom of the state require that a citizen remonstrance may present a remonstrance to the legislature to be heard and considered before a committee of the whole. Your Honor, I'm not demanding that they take action. I'm simply asking for my opportunity to be heard. That's all the Constitution prescribes, is that the cause of action detailed in my pleading simply secure me the right to be able to present it through the clerk, and that the clerk present it in such a manner, no different than Rule 4 today. Rule 4 today obligates the speaker. The ministerial duty of the speaker today in Rule 4 says he shall refer all bills. Well, that used to read, he shall refer all petitions, which goes on to include memorials, which it currently cites. So when they say they have no duty to act, they're in error, because Rule 4 currently uses the word, the speaker shall refer all bills and memorials. Memorials, by their definition, read James Madison's memorial and remonstrance. Memorial under law is defined as a remonstrance or a petition. So there is a duty to act, and he's chosen not to. And of course, the rules are missing because they've only got half the rules. To continue. So the legislature, it's for the legislature to decide, not for the speaker or the president of the Senate. The defense has confessed that there are no such rules under which a remonstrance may be considered by the legislature, because they remove the rules. I don't see, I'm beside myself on that one. How do you remove the rules and say you have no obligation to act? Number 4, the petition for the writ of mandamus is proper because the Speaker and President Morse, as the elected leaders of the House and the Senate, have always been delegated this responsibility to enforce the ministerial duties conferred upon them by the previous rules of the House and the Senate, as evidenced by the House and Senate journals, and the current House Rule 4. Such rules have historically required that the Speaker of the House and the President of the Senate shall refer, just like it does now, shall refer or cause to be referred citizen petitions or remonstrances to the appropriate committee, or to establish a special committee when necessary. And I'd like to ad lib for a second. The founding fathers, when you read the first 4 years of the state legislature in the early state papers in the archives, you will discover that they put a greater importance on the repeal of bad law than they did making law. This is why the emphasis of assembling as the legislative body as a whole, because Article 31 says what? The first obligation of the legislature is that they shall assemble for redress of public grievances. First, they shall make laws to resolve it as a remedy. Second, to continue, the prohibition is proper. The Speaker of the House and the President of the Senate and the defense have not brought to your attention any authority for their conduct. As such, actions are ultra vires and they're non-feasance. There's no constitutional authority delegated to the Speaker of the House, the President of the Senate, to alter, amend any provision of the Constitution. They have no authority to conceal or obstruct by rule or omission of previous rule any referral of a citizen's petition or remonstrance to the legislature. 6, the defense motion should be dismissed. The defense has failed to establish any lawful authority by which they may ignore the requirements and duties of the Constitution, its historical precedents, its usage and custom. They have intentionally caused to be enacted rules of procedure void of their obligations and duties, so as to not carry out the duties required by the Constitution. They claim they have no duty to act because they've removed the rules. 7, the defense entire case relies upon smoke and mirrors, obscuring and redirecting the court's attention to other non-relevant issues while never citing any constitutional authority or relevant case law to substantiate the infringement on the plaintiff's rights. These questions before the court have already been answered by the New Hampshire Supreme Court in Burt versus Speaker Shurtleff. The Supreme Court has stated clearly the legislature has no authority to use its internal rulemaking power to amend, alter, or infringe on any provision of the Constitution. Excuse me. Your Honor, this case is simple. The right of petitioning or remonstrating is an ancient right. It is the cornerstone of the Anglo-American constitutional system. On June 11, 1776, the colony of New Hampshire authorized by a council and assembly a proclamation to draft the New Hampshire Declaration of Independence. Most people don't know this. And on June 15th, the following is the first sentence of the draft. It states, as the first reason for the Declaration of Independence was the deprivation of the fundamental right to redress of public grievances by petition or remonstrance, which had evolved from the Magna Carta 1215, Petition of Right of 1628, Grand Remonstrance of 1641, the English Bill of Rights of 1688. The following is the first sentence. Whereas it now appears an undoubtful fact that notwithstanding all dutiful petitions and decent remonstrances from American colonies, the utmost exertions of their best friends in England on their behalf, the British ministry, arbitrary and vindictive, determined to reduce by fire and sword our bleeding country to their absolute obedience. There you go. This was the foundational element. The petitions of the founding fathers, they were all rejected and met with further injury. It's of critical importance to this case to understand the right of public grievances by petition and remonstrance in our constitutional scheme not be fully appreciated without the awareness of an extraordinarily rich history here in New Hampshire. The Constitution of New Hampshire, ratified by its inhabitants on October 31st, 1783, the provision of the Constitution is still some of the laws of the land today. Article 31 and 32 have never been repealed, and therefore they should be in full force and effect until altered or repealed by the inhabitants of the state. They cannot be amended or repealed by any branch of government. The defendant's motion to dismiss should be denied as their motion is void of any constitutional authority, as I cited earlier, which would allow the legislature to suspend its obligation to perform its duties as required by the Constitution, or any authority that they and they alone may now decide to suspend or deny the plaintiff of his rights secured by the Constitution. Your Honor, I have a question I'd like you to ask the defense, which is, Attorney Lehman presented the issue of that the right still exists, that it's strong, but there's no remedy. There's no remedy in the existing rules. There is no obligation for them to act. This is the nexus of the problem. You can't remove the rules and then say, Your Honor, we have no duty to act when the rules are gone because you took them away. To move on, the issues in this case are justiciable, and this court has a duty in the matter. The New Hampshire Supreme Court, I referenced earlier, Burt versus Speaker, quote, no branch of state government can lawfully perform any act which violates the state constitution. Further quotation from that court, claims regarding compliance with mandatory constitutional provisions are justicable. Quotation omitted. It is our duty, we stated, to interpret constitutional provisions and determine whether the legislature has complied with them. Your Honor, that's why we're here today. I'm not asking you to do anything extraordinary. I'm asking you to do what has been usage and custom, what is a fundamental right It is not an arbitrary thing for the legislative body to use their rules to simply decide what is presented to the body and what is not presented to the body. They claim they have no duty to act, but in fact they do. They do because they decide. Where is that authority? There's no rules to indicate what happens. They rely on Rule 18, which is a circular trash can. Filing it in the clerk's office is not a solution. And I'll end my comments with there and save the rest for my closing argument.
Thank you, Mr. Richard. I want to give Attorney Cianci, Attorney Lehman, an opportunity to respond to any of the arguments from Mr. Richards, and I'll give Mr. Richard a chance to respond if he'd like to. Attorney Lehman, anything further on behalf of Senate President Morse?
Sorry, I was muted. Just briefly, Part 130, Article 31 doesn't work together with Part 1, Article 32 in any way that creates what Mr. Richard describes as a cause of action, or which I would characterize as an affirmative duty on the legislature to act in a certain way in response to a petition or remonstrance. It simply says that the legislature shall meet, and what the purpose of that meeting is, which is generally to redress public grievances and make such laws as the public good may require. I do want to address Mr. Richards' argument that the legislature, because it seems to be new today, that the legislative rules are required to have certain content. I will strongly disagree with that for the precise reasons that Part 2 Articles 22 and 37 specifically assign to each legislative body full authority to make their own rules. There is no requirement that any specific rule be enacted. And in the Hughes case, Hughes versus Speaker in 2005, and I believe my recollection about this is correct, the Supreme Court said as to legislative rules, the bodies can have them and they can follow them or they can ignore them at their own choice. That is the prerogative of each legislative body to do that. Also, as to rules, I disagree with the claim that anybody has removed rules. Rules don't get removed. The power and authority of each legislature ends at a time dictated in the Constitution, and when the legislative authority expires and a new legislative body is sworn in, there are no rules. They are, in a purely democratic state, a body of 24 and a body of 400 with the ability to act based on a majority. Adopting rules is typically one of the first orders of business on convening or organization day, when the bodies get together and decide how they're going to go about their business. And new rules are adopted in every new legislative body. There is no carryover. There is no obligation. A simple majority can adopt whatever rules they think are going to be best suited for the circumstances that confront them in that session. Each legislative body is a new creature. It's not obligated to follow the rules that its prior, the bodies that came before it used it. In fact, there's law that says the old legislature can't dictate the process to be used by the new legislature. We don't do that. The right of the people to have their elected representatives come together cannot be controlled by the past, except insofar as that past is encapsulated in the Constitution. That's what limits legislative bodies, not what their old rules used to be, again, unless they're founded in the Constitution. And again, it comes back to what I really think is the simple question, which is, does Part 1, Article 32 compel the legislature to take specific action in regard to Mr. Richards or anybody else's petition or remonstrance? And I submit that it does not, and he has failed to come forward with any compelling constitutional authority to say that it does. So for that reason, I would continue to urge you to dismiss his petition.
Thank you, Attorney Cianci.
Thank you, Your Honor. The only thing I'd add is sort of getting to the issue of the relief sought by the plaintiff in this case. He's really seeking three forms of this court's equitable ability to grant equitable relief, whether it be via mandamus, prohibition, or injunction. All three, as the jurisprudence on this establishes, these are extraordinary remedies. It's a discretionary remedy with this court. And in order to grant the equitable remedy, the plaintiff needs to establish, particularly for mandamus, that there is a ministerial duty to be performed. That is, that the actions he's requesting this court to order the legislature are not discretionary. And we don't believe that anything in either the complaint or his objection sort of establishes a ministerial duty that can be ordered by this court. And the second part of that standard is that he needs to prove a clear legal right to the relief. And it's our opinion that under the cases we've cited, that there's nothing in the plaintiff's argument that establishes a clear legal right to a writ of mandamus related to his remonstrance. And then secondly, regarding the injunction, the common standard being the likelihood of success on the merits, we believe for those foregoing reasons, this court should not grant injunctive relief to require the legislature to do something or to refrain from doing something in either case. We just believe that either standard has been met for this court to impose the remedy sought by the plaintiff. Thank you, Your Honor.
Thank you, Attorney Sansi. Mr. Richard, since you're the petitioner and you're the respondent on the motion to dismiss, I'll let you you have the last word with regards to the issues raised.
Very good. First comment in regards to Mr. Attorney Lehman's comments about the use of the rules and his perspective on use of the rules. Again, this is where the John Burt decision really addresses this issue in great detail. The rules of the House and the Senate cannot be used to infringe upon any requirement to the Constitution. Two, the obligations, this is not discretionary. The obligation is to the Constitution. The legislature doesn't get to decide by what rules it will enact as to which provisions of the Constitution it will now deal with. In my case, with the remonstrance, they've confessed that there are no rules by which a remonstrance can be considered to repeal the substance of the remonstrance. So if there are no rules, well, the Constitution says clearly that I have the right to at least present and to be heard and to be considered. That hasn't happened. And they've stated that there's no rules to make that happen. So that's not on me, that's on them. And the old rules, as Attorney Lehman said, do not apply as you go from one legislative function or session to a new group of people. I don't disagree with that. What I disagree with is that the new rule can't be void of previous obligations. In other words, the Constitution is still supreme. The legislature must still enact the necessary rules required to carry out its duties. And lastly, the Constitution is not discretionary. And that's really the nexus of this. This is not, and I really want to close out with this commentary. Attorney Cianci, in his previous pleadings, alluded to that the Constitution and these obligations, there was an internal memorandum generated by an attorney everyone here probably knows well, Chuck Douglas. When he was legal counsel for the House, he drafted an internal memorandum that explained the history and usage and custom of this right of redress by petition or remonstrance. There were more than 18,000 petitions. I cite this in my plea. There were more than 18,000 petitions filed in a span of more than 100 years. And to use Mr. Cianci's words, it simply fell out of favor. The defense isn't bringing any evidence forward here that simply falling out of favor is not a constitutional amendment. It's not discretionary. And that's what they're here to argue, is that they do have the discretion to enact rules that are void of their obligations to the Constitution. And I'm here to plead no. And I think that would be my last comment at this point.
Thank you. I want to just commend Mr. Richard, Attorney Lehman, and Attorney Cianci for what's was very interesting argument, and I will assure all of you that I will give thought and consideration to the arguments that were made. I will take the motion under advisement, and but I do appreciate the really fine advocacy, including by a non-lawyer who did I think really an excellent job of laying out his arguments here today. I appreciate good advocacy, whether it's a lawyer or a non-lawyer, and there's good advocacy all the way around. But I appreciate it. Thank you all very much. I'll take the motion under advisement. Thank you.
Thank you, Your Honor.